Hope I'm audible. Just drop a reaction if I'm audible to everyone in the lobby. Thank you. All right. So thanks everyone for joining. Apologies, we got a little delayed because of people and our presenters lining up. So good evening, everyone, and welcome to this insightful webinar on India's DPDPA journey. We're trying to understand what has been the journey so far and how are we bridging the legislation to implementations. And the day couldn't be much better as we celebrate International Data Privacy Day. It reminds us of the growing importance of safeguarding personal information in this digital world. With India leading, DPDPA, the advent of Indian privacy era, and which is emerging like a key milestone, our nation, our organizations, and every one of us, we're taking small but critical steps towards safeguarding digital rights and bridging legislative intent with practical implementation. We've seen the law. Some of us have actually been in a forerunner space in terms of such implementation. And then we'd like to understand from industry experts what they have to say on this day. Good evening. My name is Kumar Priyank. I'm the Chief Privacy Officer at DPDP Consultants and a co-founder of GDPR Consultants. It's my privilege and an honor to guide today's insightful discussion as we delve into the complexities and opportunities surrounding DPDPA and the data privacy journey of India. We're honored to have with us exceptional panel of speakers who have made significant contribution to privacy, cybersecurity, and digital law. Allow me to introduce none other than Mr. Vijay Shankar Nagarajao, popularly and lovingly known as Navi. He's a pioneer in cyber and data protection law in India. Navi is chairman of FDPPI and founder of cyberlawcollege.com, India's first virtual institution for cyber law education. With vast experience in GDPR, HIPAA, and DPDP compliance, he has received multiple accolades, including Lifetime Achievement Awards for contribution to the cyber jurisprudence and privacy. So thank you, Navi, sir, for joining us. We also have Mr. Naresh Madhav, an IIT Delhi BTech Computer Science graduate and a law graduate from Faculty of Law, having years of experience working in MNCs like TCS, Interglobe Technologies, and years of experience in privacy domain. Now he's our DPO as of moment. He's currently assigned as a DPO for India, Southeast Asia, Australia, New Zealand for the BPO services giants in a Fortune 500 company known as Concentric Corporation. We also are joined by Dr. Pawan Dugal. We're still waiting for him. He's right now into a media release. Pawan, Dr. Pawan Dugal will be joining us soon. Oh, great. Good to have you, sir.
Yeah, Dr. Goswami is in. Yeah.
Okay. So, okay, let me start then with introducing Dr. G.K. Goswami, a decorated officer of Indian Police Service in the rank of an additional Director General of Police, UP cadre. Dr. Goswami is a Fulbright Nehru Fellow from Cornell Law School and holds distinction being the first Indian to complete the DSc in Forensic Science and Law. His extensive experience in cybercrime and law enforcement officer has a unique and valuable perspective on data protection and security. And an industry now named Dr. Pawan Dugal, who's a renowned, recognized leader in cyber law, cybersecurity, and artificial intelligence law. He's ranked among the 4 top cyber lawyers in the world and has dedicated 26 years to shaping India's cyber legal framework. Dr. Dugal is also the founder and chairman of International Commissions on Cybersecurity Law and president of CyberLaws.net. He has authored 199 books and practices as an advocate in Supreme Court of India. I just couldn't be more proud in having such knowledgeable and vast group of panelists on our webinar today. So thank you, everyone. Well, when it comes to data privacy, a concept that has not been very familiar with a lot of us, when we saw DPDP in its essence, we were pleasantly surprised and very happy that India is going to have their first digital personal data protection law. I'll start with you a question, Navi sir. When it comes to the privacy, once I heard that privacy is a rich man's jewelry and, poor people don't care about privacy. And considering the kind of digital literacy we have in the country, is data privacy a myth or is DPDP shaping it into reality with this law enactment?
Thank you, Priyank. So actually, privacy is a new concept in India because it's a cultural issue. So in EU and all, people have been aware of the right to privacy for a long, long time. In India, we are just getting into the real realm of privacy. In fact, after the Puttaswamy judgment, the Supreme Court held that privacy or right to privacy is a fundamental right for an Indian as per our constitution. Until such time, privacy was being recognized by Supreme Court in different say judgments. Initially, as a physical privacy concept, that is, every person, for example, home is supposed to be his private area, and even police should not unnecessarily disturb the person in the night, kind of a thing. Home is the castle, was what the correction judgment said. Of course, this concept has been there in India from historical times because we trace this to our in classics like this Panchatantra stories. At that time itself, India had recognized that home is the castle. However, when it comes to the current generation, people are yet to appreciate what is the importance of privacy. People understand cyber crimes and the impact of cyber crimes on their lives because there are people who have suffered heavy financial losses because of identity theft. People have also suffered because of, say, deep fake and such other identity manipulation. Actually, they are all privacy issues. Only thing is we don't recognize that they are actually privacy issues. All the risks associated with cyber crimes are in a way associated with privacy. But earlier we were looking at it in a different way. So today when you ask somebody that they may say that I don't know what is privacy kind of a thing. I don't give any value to my name, address, etc. If you say privacy is sharing of your name, address, mobile number, people are unable to understand what is the importance of that. I am not worried about it. You ask them, are you happy with your Aadhaar being shared? Then they may at least hesitate a little, but afterwards they may say, I have already shared Aadhaar with so many people. But when you know that an Aadhaar number can be used for, say, doing a KYC or opening a bank account in your name or for other crimes, and then ask, in that scenario, do you think Aadhaar is an important, data which you have to perhaps keep it safe? Then they will understand the importance of privacy. So the word privacy or the term privacy as we have taken from the Western world may not be immediately understood by our people, but the consequences of loss of privacy, I think people will be able to understand. So this is one of the thoughts which is before us. How to make people realize that privacy is an important right, because of which it has been considered as fundamental right. So privacy associated with identity, loss of privacy means loss of identity. Probably if your Aadhaar is perhaps registered by somebody else with your, let us say, thumbprint, then obviously you know that you have lost your identity. We are yet to actually make people understand that kind of privacy implications. Once it is done, I think this culture will slowly come up. Today, it is there with the educational people with education, but others will try to understand this concept as we go along. And professionals like us have the responsibility in making this understood by the ordinary people. Yeah, Kumar.
Thank you. That's a great perspective. And this is a question for Dr. Goswami. I think you've been very close to public. Do you think, as a data principles, we also not have given a lot of weightage to our privacy? We have spoiled organizations and fiduciary by recklessly giving our data. I always say we sell our data like candies, and organizations like are chewing it like a chewing gum as long as they want. Do you think there's a certain amount of responsibility that the citizens and individual also have when it comes to respecting their own privacy and understanding the value of it before it is given to the organizations to process? I think you're on mute, sir.
Hello.
Yes, sir.
Good evening. Can you hear me now?
Yes, we
So
can.
good evening, everyone, and thank you for inviting me and having heard so much great persons sitting over here, including Nabi Saab and many more, Duggal Saab also. So as you rightly mentioned that probably in India, although privacy has its roots since its ancient time, and still we have a lot of, concern about our privacy, whether our females or whatever we have. So privacy is very sacrosanct. But of course, in legal term, we have introduced, as rightly mentioned in Swami case in 2017, as fundamental right. It has not been mentioned categorically in our legal system before this case has brought it as fundamental right. But the problem is that we are not very much aware about the data, how our data is connected with the privacy. So whether we are well educated people, we left, right, center share our critical information not only to various fiduciary in different way, but happily we share. For if we go to market to buy something, they just ask us to fill a form. They ask almost everything, including our date of birth, just to be so-called, then your marriage anniversary, about your mobile number, email number, and not only they get these information, they share it for other, people for the purpose, and that data is being sold. So this is a very critical scenario, and it is worldwide, not only for India per se. So I think the DPDP Act has put, you can say, a kind of commitment and responsibility of the fiduciary to maintain the data, that the purpose for which the data has been shared, they should not misuse it. And a lot of, you can say, the right has been provided. The data principals have been empowered in terms that they can withdraw at any point of time, they can correct it, they can ask, and they have been given the empowerment that in case there is any breach, then they should be informed. And not only that, the schedule particularly attached with these rules and DPDP Act particularly, there is heavy fine for breaches, and that is up to 250 rupees, 250 crores. So I think now people should be well aware, and we must be knowing that because of our ignorance, our data is circulating all around, and that is why this digital arrest, the digital frauds, and various stalking, and many more things. We are very fond of making friends on social media and all. We share all information. We are going to Mahakumbh, we are going to this place, that place, and by way of that, it is not only data which is actually the information we share on our open, public platform. That is even more challenging. As a police officer, I have seen many crime happening because you have shared the data in public domain. The people know that the house is empty, and people have gone to some, outside for 3 days, 4 days. So easily they are, I think there is a need actually that prevention is better than cure to understand. And in case of cyber crime, particularly data protection, awareness is very important. I don't think that even 1% of population is aware about DPDP Act, DPDP rule, what data means to them. They sometimes feel that data means some statistical value or something. They are not aware that data means what. So first of all, we should communicate to the people that what data exactly mean in terms what we are having Puttaswamy case since 2017 and 18, Aadhaar case and earlier right to privacy as fundamental right. But how many people are aware? I know not even police knows properly. Police in and out. Many times unknowingly, they go and search the houses, whether it is required or not. They search you in person. They search your mobile phone, your all gadgets. So I think there is a need actually to interpret the nuances of K. Puttaswamy. I have never seen even an article whereby how Puttaswamy case should be implemented in public domain and how right to privacy engaged as right to life or fundamental right. What shall be the implication? So I think it is the duty of the academia, the people who are aware, to make things simplify for common consumption. It is generally being taught in maximum in the legal schools or platform like you are doing. It's a good job. But this information should reach to the downline at the last mile, to the last person. Because nowadays, everybody is using internet. Everybody is sharing so much data. And don't think that data is important for we people only. Because if the people who are little empowered, they are aware, they can at least go and complain. But the person who is sitting in a rural area may not be well aware. He does not know even what is happening all around. He does not know what kind of data has been stolen. So these are the real challenge. And I believe that awareness is the first and foremost important, field where everybody should contribute. Yes.
Thank you. Thank you for those insights, Mr. Go. Absolutely agree. I mean, that's why we always talk about having a shared responsibility. It's like we know police is there to ensure that we are safe, but personal safety is also a citizen's responsibility. Taking those protocols is necessary. I think that's probably we also see there are duties associated with data principles in the law, and not only obligation of the data fiduciary. I think when both do their shared responsibility, I mean that is the way this law will be properly enacted and enforced, and will have that kind of value that you're saying. But coming to the business aspect of it, and I think a lot of business community have joined, and this is for you, and Naresh, especially I know wearing a DPO hat is like wearing multiple hats, and an expectation to pull rabbit out of every hat. Now, because you're not restricted to one, though you could be representing the privacy office, you have everything, right? From the human resources to the marketing, to your customers, to your vendors. And especially in this global framework, what do you think are the usual challenges that the organizations are currently facing at your level as global organizations when they start thinking about implementing DPDP, how they're aligning them with the current framework that they have to the DPDP framework?
So, hi everyone, very good evening. Thanks, Kumar, Priyank, for actually inviting me here. It's so nice meeting Naviswar here. He has been my even guru. I took some courses with him with FDPPI, and nice meeting Bhagwan sir as well and Goswami sir. So I personally feel that companies like different, there are many companies in India who are actually even not aware about the existing laws which are there, like which are there in IT Act, which are there, the certain notification guidelines, and the requirements which are there are even unknown to some certain companies. Now, what I feel that for companies to actually implement this, the initial step has to be gap assessments, where we actually see that, okay, what all we have in place in our company. Then we go about and try to find lacunas. Okay, this is a particular area where supposed to talk about data discovery. We are actually wanting to know where all our data is residing. So in taking those kind of steps, having like all the small gaps in your company implementation noted down in a sheet, and then trying to find okay, whether it is compliant with the existing law which is there now or not, is something which we need to, which every company should actually do, the gap assessment. Then it comes to risk assessment, where they are also trying to see whether the risk associated with it is there, managed properly or not. So for companies in India, actually, and moreover, Goswami so very rightly said that from very grassroots level, like for our employees also, we need to, tell them about what privacy exactly is, because I have seen in my company, even our agents or people who are there are not knowing what privacy exactly means. So spreading knowledge or maybe awareness is one of the major aspects, and even industries to comply with it, so that uh, because people are, if are not knowing what the nuances there and what is the importance of privacy, they sometimes take it very leniently and they're not bothered about what the repercussions which the company itself might face. So spreading awareness is and trainings, privacy trainings are one should be major aspect of having implementation in any company. So I mean
Right.
basically.
I think that is, yeah, and I think I concur with you with a lot of organizations we're meeting, and I think that there's definitely one challenge that they came along with that we want to do and we want to comply. This is the law that we cannot. There's no exemption, but a privacy aware workforce is what we need, because when we implement something like this, we want it to cascade it to the entire organization. I want them to understand the value and what comes out of it. So absolutely in agreement with you. Well said, Ms. Naresh. Uh, Navisa, there is, when we speak with different organizations who are at this stage planning or, or probably have gone ahead with the compliance, there's a how effective this law is going to be. I know organizations are thinking, well, there was an act, then it will become, the draft rules will come, this will further get enforced. The privacy notices of the organizations, apparently a lot of them are just acting like paper tigers at this moment. There's a lot of to preach, but very less to practice. Looking from an organization standpoint, somebody once told me when there is a law in Europe, people say, "Oh, there is a law, let's follow it." And when the law comes in India, they say, "Let's break and see what happens." And now there are penalties associated. What do you think should be an organization perspective at this point in time to kickstart this organizational compliance?
Organizations should look at it as their ethical responsibility that if there is a law in the country, we need to follow. Of course, if we don't like the law, we can try to get it changed. That is a different issue. Okay. But if we are not able to get it changed, and if the law is passed, then we have to follow, follow that law. Like if there is a road and police have one way there, we may feel that one way is not required here. But still, if it is a one way, it is a one way. So I think that Indian corporates develop that kind of respect for law. Okay, so that is something which you cannot teach them, except if they are fined, then they will perhaps realize. But that is a wrong way of learning, but I think that is the one way it can happen. But the government is unlikely to start with a heavy fine kind of tendency to start with. They may start with issuing, let us say, notices directing the companies to change their practices. So real penalties, we may have to wait for at least 2 years. But most of the multinational companies are aware what is happening in the GDPR scenario, where penalties to the extent of 8,000 crores, 10,000 crores have been imposed on companies, of course, like Google and Meta and other things. So any person who is aware of the global scenario knows that this law can really hurt. And what we are trying to do is we are trying to alert the companies that whenever there is a data breach, it is not only the civil penalties of DPDPA which may hurt you. I may actually invoke the Information Technology Act and try to bring in certain criminal penalties, because a data breach may have an adverse effect on a data principal. And the data principal is a typical cybercrime victim whom we are talking of. And that person has got remedies under Information Technology Act, one of which is prosecution by the police as a cybercrime. And prosecution under the Information Technology Act is associated with Section 85, which actually exposes the executives of the company to imprisonment for the offenses committed through the company. Now, if companies understand this scenario, that it is not just negotiating with the data protection board and somehow convincing them not to fine me or something like that, it is possible that the CEO of the company has to face a charge of criminal prosecution, then they will be perhaps they're not taking this lightly. Ultimately, of course, we need a strong data protection board which actually concludes a few inquiries quickly and imposes fines, then perhaps the attitude will change.
Thank you. Thank you, Navi, sir. And I also see Dr. Pawan Dugal has joined us. Thank you for joining us, sir. It's an honor to have you here. And I think there's a question that I've been meaning to ask you, and I'm glad when you're here, I'll ask you. Every legislation, when they come and they're introduced in the organization in the country, there is, of course, there's a set of challenge that it brings. There's a set of confusion, some misconceptions, and some lingering questions are in organizations' head or the people head. A lot of organizations still believe that the IT Act is something they are being governed by, and then there is the DPDP. So when you see this new law coming in, of course, with a set of own challenges, limitation, and granularity expected from the rules. Do you think DPDP has supplemented or it has replaced or it has just added to the data protection provisions under the current other data protection regulatory act or an IT act or something like that? How do you see this crossover within these two laws?
Well, I see the Information Technology Act 2000 as a mother legislation, an umbrella legislation, under which one smaller legislation has come in, which is the DPDP Act. This legislation is only dealing with one aspect, which is protection of personal data. It's important to understand that the definition of data has already been given under the Information Technology Act 2000. Further, Section 81 of the IT Act says that this is a special law, and the provisions of this law prevail over anything inconsistent therewith contained in any other law for the time being in force. Now, this special nature of the provisions of the IT Act don't get matched up with the DPDP Act, because DPDP is not a special law. Yes, it says to the extent that you're talking about personal data, my provisions will prevail. But otherwise, it at best is a supplemental law, which is supplementing the broad provisions of the IT Act. Of course, needless to say, it's, the ambit and scope of the DPDP Act is very, very narrow. Broader aspects are broadly covered under the IT Act. But the intersection between the IT Act and the DPDP Act is likely to create some intrinsic potential challenges, conflicts. We need to make sure that these conflicts need to be minimized so that at least there's a harmonious interpretation and working together of the IT Act and the DPDP Act and its various provisions in harmony.
Thank you, sir. That is absolutely well said. But there has been a lingering question also that a data principal like me, if I'm not from a privacy community, I will have. What is in it for me? So is penalty a reasonable deterrent that the organization should fear? I know when something like this happens or non-compliance to this law happens, it can do, it will have a ripple effect. We talk about the financial penalties that can be levied to them. There's a loss of digital trust that can translate into a loss of business. Stocks get tanked for whatever. But as a citizen of India, if my data has been compromised, if my rights have been harmed, there has been a lot of question in the industry. Would a data principal be compensated for the loss under this law? There's no clear provisions, but what are your thoughts on that?
Well, the law is very, very clear. The data principal is not going to get a penny for violation or breach of his personal data. This is one of the biggest drawbacks of the DPDP Act. You see, first and foremost, the data principal suffers the first jeopardy, which is that his personal data stands compromised. Rather than trying to remedy that particular problem, you go ahead and put him a victim of double jeopardy by making sure that he doesn't get a single penny of the fine that's going to be imposed. On the contrary, the fine goes to the government of India in the form of Consolidated Fund of India, which is like, adding salt to injury. So I believe that the DPDP Act has not really lived up to the hopes and expectations of the data principals, because they have effectively no remedy. Mind you, under Section 43A of the existing IT Act, they could still seek for unlimited damages by way of compensation against a concerned company in case if they find that as a result of negligence or failure of the said company to implement and maintain reasonable security practices and procedures, they have suffered injury or loss. But now the DPDP Act has snatched away that remedy as well, because Section 43A of the IT Act will stand repealed the moment the DPDP Act comes into force. That being so, there's no effective comparative remedy or provision that's been provided under the DPDP Act for the data principles. There's nothing in the DPDP Act for data principles, and that's why it comes in as a big sense of disappointment. More importantly than that, it also tends to sense in an element of discontentment with the existing capability of the existing legal framework. See, at the end of the day, law should only be formed for the purposes of providing effective remedies to affected persons. But in case here data principles being the affected persons don't get access to any kind of remedy, then I think it's a kind of a classical case of ignorance of the legal interests of data principles. That's a big drawback of the DPDP Act, and hopefully it tends to get remedied by appropriate amendment. Till that time, the data principles have no choices but to primarily go under the remedy for damages up to 5 crores under Section 43 of the Information Technology Act 2000, or to go for some of the criminal offences which are defined under the Indian Penal Code and also under the Bharatiya Nyaya Sanhita. But if you're looking for any remedies under the DPDP Act, sorry, the DPDP Act doesn't provide you any effective remedy of any kind whatsoever as a data principle.
Well, that's kind of saddening, and I hope the Section 40 that talks about that government may bring something new to the law, may address this impending questions that we have. Mr. Goswami, you, as I said, you've been very close to public. You've seen, I'm sure the urban sector and the rural sector of India as well, from an organization standpoint, from a data principle or citizen standpoint. There's primarily a question that comes, especially because compliance comes with a cost. Of course, we can still quote Paul McNulty saying, if you think compliance is expensive, try non-compliance for that matter, which is relatively more expensive. But when you talk about smaller organizations who have limited resource and probably privacy is not on their top chart, or the priority one activity, and generation of the revenue and sustainability could be another one. What is your recommendations for organization of a small scale when it comes to, adhering to this privacy law or, to comply with this law, bringing it all the provisions? What can be done at least as a step one for these organizations? Sorry, you're on mute, sir.
Yeah, well said. I think Advocate Pawan Duggal Sahab already has mentioned many things, which I do agree. But I am very optimistic that various aspects in DPDP Act has been taken care of, although there are certain areas which need to be taken care. But as you rightly mentioned, that what kind of measures the small scale, industry or entrepreneur, they should take care for as data fiduciary to take care of the obligations they have been entitled or they have been obligated under Section 8 of the DPDP Act. In my opinion, the first problem with all these things which is yet to be addressed is what is privacy. Nowhere privacy has been defined properly, particularly in my opinion, at least there must have been some kind of definition or some indication, explanation somewhere in Section 2 of DPDP Act. So this is one very important area, that what is privacy. So whether it is the data principle or the data fiduciary, until unless we make them understood that where from the privacy start, what kind of data is shareable, what kind of data has some, more susceptible for violation of privacy. So this is one point I want to make. But coming to your question, the small scale data fiduciary, probably they have more problem because they are struggling to compete in their business. If they start taking regulatory mechanism, they have to spend a lot of resources on that. So the resource crunch is the biggest problem. But nevertheless, in my opinion, at least they should not share the data with other companies and other things, and unnecessary they should not get the data collected from the data principles, unwanted data. So they can start that kind of thing so that they should follow that kind of trap. The second point is that it is not necessary that data fiduciary willingly are sharing that data with others. Sometimes the security provisions are very weak with these type of, data principles. They may not be very careful. They may not be having all those enabling provisions or the technology. So that is another area. So in my opinion, they have to have a proper cyber security mechanism in their system so that they should not unnecessarily get trapped into the DPDP violations or something like that. The another problem which I believe for particularly for data principles, that although it looks in the annexer that the the levy is about, or the penalty is about rupees 250 crores, but the discretion is too high for data principal board. It is not being clearly defined. So the problem may be that a very big tycoon who is a businessman may be having good connect. He may be levied very low quantum of penalty. But suppose if you are not well connected, you are not well aware, you could not bring a good advocate to defend, then the quantum of fine or penalty may be very high. So here also is a catch. So they have to have a mechanism, and I think this should be defined properly, that how much, or there should be a kind of mechanism by which DP board should be, given clear regulation or instruction. Otherwise, in my opinion, this is a very, very gray area, and particularly the lower level data fiduciary, they may be in a very difficult situation, in my opinion.
Right. Great. I totally agree that there's the organizations we've seen, dealing with resource crunches and financial provisions to comply with the law. But like you said, certain things like following the principle of data minimization does not really require resource or money. This is basic adherence to the law, and in a sense of the principles of the law. Being transparent doesn't cost you money with your data principles. Collecting less than what you require doesn't require provisions. So absolutely well said. These provisions can be a Kickstarter. Naresh, you deal with global clientele, and one of the things that we often heard from global clients, we are GDPR compliant. So what DPDP can do to us? Do you think just being GDPR compliance is enough, or do you think there are additional obligations that organizations will start focusing on by shifting them to looking at where is the delta between the GDPR and DPDP and start working towards it?
So what I see is people not being aware of just territorial jurisdictions of the law, which is a major issue in dealing with clients in certain cases. So sometimes clients do come up with their ideas. They come up with a draft of documents saying that, okay, we are having EU SECs in place, and so we are compliant. And whereas the processing is happening just in India and suppose Southeast Asia country, some other Southeast Asia country, there is no need of GDPR over there. But they say, and in the end customer belongs to that particular region, the target of service is that particular Southeast Asia region. So that, lack of knowledge amongst even the industry leaders, where they are not knowing about the territorial jurisdiction which has to apply through a particular law, is something which needs to be made more simplistic. People need to be more aware of it. I have seen so there is not a possibility, even slightest possibility, that two laws are applicable on one particular region simultaneously. It is not a possible thing at all. One particular region, when only one law would apply, or one data privacy law would apply in that particular region for one set of data users. So this kind of segregation, one person has to be really aware of, really knowing it. Like in India, suppose in GDPR, suppose if you just take an example there, GDPR strictly says that any services or goods given to a particular European city, which is targeted in that region only, is going to be under the purview of GDPR. Whereas so if a client says that, okay, we are GDPR compliant and we are going to give services in it, you are servicing our end customers in India, then we would simply say that, boss, these are two different jurisdictions, these are two different laws which are applicable. There is no conflict in applicability. So we have to be aware, we have to be knowing what the territory and jurisdiction is of a particular law and apply it properly and demarcate it properly when we are having any connect with our client or our vendors in any industry.
Thank you. I do recall speaking to someone who said we're DPDPA compliant because we are GDPR compliant and we cater to all the data subject rights in India. And I said, at least call them data principles to start with. They are not data subject, even if you're GDPR compliant.
Absolutely. They can very well take practices. They can take some practice, industry standard practices being used for GDPR. They can use those practices and implement like ROPAs. You can use that kind of ROPA as a best practice to be implemented in your company for DPDPA compliance. But you cannot say that if you are GDPR compliant, you are DPDPA compliant.
So Navi sir, thank you, Naresh, for that insight. Navi sir, when we go to the organization, I think there is what we've seen right now is a tug of war between the IT and the legal. You know, somebody say this is a legal work because this is a law, and somebody says this is a technical implementation, so this is IT. And we have tried to resolve the tug of war, calling them that this is techno-legal, everyone's invited. But there's definitely an absence of a framework. Organizations are they're conceptualizing new frameworks in terms of what to do when they would like to go for the compliance. How important do you think the role of an external consultant balancing the tug and the war and suggesting them with a framework is really required at this moment for organizations? And also a supplement question is, should we be waiting as an organization or the clock is ticking?
Implementation of the compliance, even if anybody starts today, it is a journey. It will take a long time. Therefore, this question of waiting is not a wise move for a company. Okay, so they have to start right. And if the government is not going to impose penalty for say another 2 years, so it's good for us. By that 2 years, we will be learning so many things so that by the time the government is ready to impose penalty, we will be far matured in our compliance work. That is one. Second, as far as the framework is concerned, as you are aware, that we at DPDPA, we have not waited for government to come up with a framework or something like that, because what we are dealing with is the law. Law is already in place. Nobody can change the law except by an amendment to the law, which we know that it is a very tough aspect. Now the rules have come. Now the rules also cannot violate the law. So rules have to be within the act, which means that if anybody thinks that there is going to be a lot of changes after the rules are finalized and other things, I will say it will not happen. If the rules are much deviant from the law, then somebody will question the fact that rules cannot be ultra vires the law. So it cannot be something different from the act. It can give some clarifications on this thing, and where this way, for example, data breach notice has to be sent within so many hours. That number of hours or something like that may be defined in the rules. But it cannot say that the data breach notification is exempted for A category, B category kind of a thing. That will become a violation of the law. So the question of waiting is actually, to me, it is something which should not be considered as a wise move. People should start implementing it. And as far as the framework is concerned for compliance, we have already come up with a whole framework called the DPDPA, Data Governance and Protection Standard of India. It already incorporates many of the best principles. For example, Naresh was talking about ROPA. Now we say that the DPDPA process is the compliance should be process-centric. When we say that, please understand where all your company is processing personal data, and then start working on what is the data required for that process, how long I have to retain, etc. So all these principles of privacy is associated with a particular process. Later on, you aggregate all the processes, you have got a compliance structure for the organization. So ROPA is already there. And similarly, any other law which gives any good thought, we have already incorporated it in the DPDPA framework. So organizations have no excuse. To me, organizations have no excuse except procrastination, except a reason to delay the investment. They don't want to hire a data protection officer because they have to start paying salary from this month. They want to postpone it by another 2 months, kind of a thing. So there is no logical reason. And already responsible companies have started. But what they have started is the business impact, a gap assessment. Maybe let them do that. Let them take 3 months, 4 months in gap assessment, and at least the whole organization will start thinking about this. So I think if anybody says I'm already GDPR compliant, we are saying that is for EU data. There is difference in the rights protection. You just ask them, how are you doing the nomination, or who is your data auditor? So there are lots of differences. So we have to break that thought that we are already GDPR compliant. We are already ISO 27001 compliant. Those things are good, but are not sufficient. Okay. The rest of things, it takes time for compliance. So better start today. Okay. When you start the race, you know the destination. If you start late, this is not like athletics that you will be disqualified for starting early. You ultimately cover the distance. So I feel it is better they realize that they should start compliance immediately, and it is our responsibility to tell them that waiting is not recommended. Okay.
Thank you, Navi sir. And just Dr. Dugal, you are here. There's one question that I think the industry has been deliberating a lot over: parental consent. Now, is age gating enough, or age verification is enough? There are a lot of organizations who traditionally do not need or never collected children's data, but do they need to ensure that they bring in those mechanisms for age verification as a universal practice, or should be evaluated on a case-to-case basis? What are your thoughts on the verifiable parental consent that the law has just come up with?
Well, first and foremost, the law has come up with some broad parameters under the draft DPDP rules 2025. We'll have to see what finally gets finalized, but clearly there are some broad thrust areas. The law wants the service provider to identify the age of the visitor, the data principal, and if it's below 18, to get the consent from the guardian or the parents of the concerned person. Now, the problem that happens is a big difference, which is that in India, people love the Indian Jugaad school of management. So consequently, people, or specifically children, who are of ages below 18, would invariably put their ages at above 18 or above 20. Now, that being so, once that particular information is so given, the service provider takes that information to be gospel truth of the data principal and processes data. Effectively, he's processing the data of a child. That being so, here the said service provider or data fiduciary continues to be in contravention of the provisions of the DPDP Act. And that being so, complaints against the said service provider can always be levied at any one point of time. Therefore, I think we require more clarity on how the practical working of the age gating propositions are going to work. Well, they have given a large number of parameters which are very crystal clear, and hopefully that should illuminate the decision making of the respective data fiduciaries and data processors. But having said that, I still see some areas where age gating could potentially create more potential challenges. Now, the idea is that we should get all clarity so that everybody has to be on the right side of the law. The idea is that at no point of time, because of ignorance of the interpretation of law, somebody is in violation of the law, because the violation of the law is too hard. Why? Because 250 crore rupees fine per one contravention is enough to almost put a 95% of the data processors and data fiduciaries and small sector enterprises into liquidation. So hopefully there'll be more clarity. But till such time that doesn't happen, let's follow what the draft rules are saying on age gating. Thanks.
Thank you. That was a great insight, and you're absolutely right. To everyone on the webinar, the Q&A is open. Akansha, if you can just moderate the Q&A. I think there are questions pouring in, and if you can just delegate them.
Sure. So thank you so much, everyone, for joining us today. This was a great session. And I would also like to extend my thank to all of our participants for such an engaged session. I will start with certain questions. The first one would be, can you share your views on significant data fiduciary? Which organization can be classified under significant data fiduciary? So this is an open question for the panel.
I'll answer that. In the rules, what has been specified is that the government is going to designate an officer of the Ministry of Information Technology department, and he will decide what class of data fiduciary and under what criteria, like the number of data sets processed or the sensitivity, will be considered as a significant data fiduciary. Otherwise, the law already defines that a significant data fiduciary may be defined based on the volume and sensitivity of the data and the risks to the data principle and national security, electoral democracy effect kind of a thing. So that remains. But within that, if the government wants to make some changes, rules may provide some leverage, and that will be exercised by a designated officer. So as of now, what the ministry thinks is, instead of expecting the government to give a list of, say, all hospitals are significant data fiduciaries, all banks are something like that, they say that, oh, please make an assessment, self-assessment. Are you processing sensitive personal information? Are you processing a reasonable number of these things? Then you decide that you are a significant data fiduciary. If you don't, if you are a significant data fiduciary and you don't classify yourself as significant data fiduciary, then that is a risk, but a privacy risk. Tomorrow something goes wrong and there is an inquiry. The Data Protection Board will consider this as one of the violations. You did not appoint a DPO. You tell him that I didn't know that I was significant data fiduciary. Then DPD may say you should have considered from your volume and other things that you should be a significant data fiduciary. Therefore, it's possible that the ministry may try to put that in the bracket of what self-regulation can achieve. Let more people declare themselves as significant data fiduciaries. Government will be happy with that. There will be a better culture. There is no fees for being a significant data fiduciary. So it is not that if I declare myself as a significant data fiduciary, I will be actually subscribing to some government tax or something like that. But I have to designate somebody as a data protection officer. He may be one of our current officers, so I may or may not pay him extra salary. But anyway, I think it is left to the self-discretion of an organization. And I think that will continue for some time. But the government has the empowerment to decide that even though a particular organization like a medical center is considered as a significant data fiduciary, maybe they may say pharmacy centers may be exempted to be called a significant data fiduciary because they actually know only the names of the drugs, whereas the hospital knows something more. So they may try to distinguish such kind of data. We have to wait and see. But don't expect that government is going to tell. If it is done, maybe many companies will be happy. But there is an officer, if you are in doubt, I think there will be a possibility of you are checking with that person, like the consultations which GDPR provides. But as of now, ministry is reluctant to take that responsibility. What if the ministry makes a mistake, that you are a significant data fiduciary and ministry makes a mistake? Then they will have to take the liability for misclassification. I think that they are trying to avoid. Yeah.
Thank you, sir. Very rightly mentioned, because whenever we discuss about significant data fiduciary under Section 10, also they have clearly mentioned that you need to look at the high risk and sensitive category as well. So most of the organization, and as a data principal also, we need to understand that if my name and my email address is getting breached, this data is not considered a high risk. But if my financial information, my healthcare information, and additional information is getting breached, that could result into a high risk activity or maybe a high risk crime. So organization needs to consider these points. Thank you so much. We have another question. So as a data principal, how do we know, or how do we understand that our existing data fiduciary is not doing any onward data transfer, or they are not sharing our personal data with another data fiduciary without our consent?
One can answer this.
Well, there are no golden principles to tell you that. You'll have to get for cogent evidence to find out whether he's doing something wrong or not. But having said that, I think no data fiduciary in its sane sense of mind would want to do that. Primarily because of this 250 crore fine, Damocles sword, that's likely to be hanging on the head of the data fiduciary. So having said that, there will always be black sheep, but it will be up to the user to then collect the relevant evidence that the data of the data principal stands compromised or stands potentially shared with some third party, in which case it will again become a classical case of personal data breach, which will then bring in more obligations of reporting, not just to the Data Protection Board, but also reporting as a cybersecurity breach to the Computer Emergency Response Team of India under the IT Directions 2022. So it's going to trigger off a large chunk of actionable items to be done. I think any prudent data fiduciary would not want to walk that particular walk unless until you're a fly-by-night operator, and unless until you think you're willing to take the law by its horns. But that's about all. There is no proof. In fact, anybody who would want to share your data would invariably not want to leave behind the electronic footprints so that the same can be used for the purposes of prosecuting or going after the said data fiduciary. So it's all dependent on the facts and circumstances of each case.
Right.
Thanks.
I know we're just, I know this has been very engaging discussion, but there's one question I have, and I think it will resonate with a lot of them. There's a lot of organizations asking question. I'll just have my closing question to the esteemed panelist. How, when it comes to an organization kickstarting their compliance, how soon is too soon and how late is too late? Should we wait? Should we start? Or should we deliberate more? What are your thoughts?
I think Navi is the right person to say, but he's said it absolutely correct. It's not a wise decision to wait. The fire has already started. So start putting in fences in your ecosystem so that the fire does not reach out to you and you don't get exposed to legal consequences. But with that note, I want to hand it over back to Navi.
I made it abundantly clear that if we want to hear, we want to hear on the safer side. If you want to have time, we want to have as much time as possible. We are not expecting government to actually withdraw this act after some time. So it is going to be there. It may come after 2 months or 3 months. So let us all start compliance activities as early as possible. And depending upon our capabilities, we will take our own time. That is always better.
So I just want to add one thing here, Kumar, that, we have been meeting a lot of clients and all of that. So we have to understand that in India, we have never been exposed to the culture of privacy or data protection before. So this is the reason we have to start early with the compliance practices. We need to make changes into our processes.
Oh, absolutely. I think there's a lot of sensitiveness. I mean, we've been talking about spreading this awareness about DPDP for a while, and we've been speaking at a lot of events, and I think a lot of us would concur that 6 months before it was more about what is DPDP, and today all we get to hear is how to go about DPDP. So that shift, that is something that has been very evident. Okay, so I know we've taken a lot of our time from web. I know there are more questions. We'll definitely like to address them with our panelists offline to the participants, but I sincerely want to thank the apology for being a little late because of some technical glitch, but thank you everyone for your participation. Team panelists, your views have been very, very insightful, and I think it's going to clear a lot of confusion and so that people had, and it will really help we as an organization, as fiduciaries, and as a country to build that privacy culture we all have been waiting for. With this closing remark, I thanks Mr. Navi, Naresh, Dr. Duggal, and Dr. Goswami for your presence, and all our webinar panelists. There will be much more coming in, but thank you. Namaste.
Namaskar. Thank you.
Thank you, everyone.
Thank you.
Thank you.